Let me now introduce our third speaker, Marta Bayer. Marta is coming from New York. Marta is lawyer and master in telecom. She has a technical and humanistic vision at the same time, what is so unusual and so uncommon. She is the legal advisor of the ECTC, and she has deep knowledge of the American point of view regarding regulation, and she will instruct us about the traps that most of the telecom services contracts have. All it's about terms, and all it depends. Marta is also a ski instructor and coach, and she's going to teach me something about the ski during the weekend. Thank you, Marta, for coming.
Thank you so much for inviting me. Oops. Sorry, we're out of order. Do you want to go next, or do you want? Okay. Uh-oh. No? So while we're figuring this out, let me first say...
Lawyers are never good with technology.
No, these
First, let me say... There.
Okay.
First, let me say thank you so much to Barcelona. This is only my second time here, and I have learned all sorts of new words for foods that I now love. Thank you so much to the Arjalik family for, particularly to you, Augustine, for insisting that I come. To Uhe and Nuria and Nacho, thank you. Thank you to Cisco for hosting us, and thank you to everyone else who's involved in this event. So this slide, it is not a scientific slide, but does anyone have any idea of what these people have in common? And it is not scientific. It involved people that I spoke with randomly. And you will recognize some, you may not recognize them all. I'm not sure I recognize all of them. But they are all people who changed the world for good. There are certainly many people who are missing, but these are all people who have changed the world for good, the contemporary world. When people suggested names of war criminals or others, they were left off. But these are all people who have changed our world. And if you don't recognize all of them, I can fill you in later. But this man changed our world for good or not is arguable in the last 5 years, and this is Edward Snowden. And Edward Snowden's revelations about what the government had, records that the U.S. government was holding, these have changed all of our worlds, Patricia's and mine, and yours, I'm sure. He's still in Moscow, I believe. But his revelations changed the way we think, changed the way data is managed. One very important distinction between how Americans view data security and privacy and Europeans is that Americans view privacy as a matter of commerce. Americans like our information to be secure, but in Europe, privacy, the right to be forgotten, is considered to be a fundamental right. Americans do not view it with that level of severity. That doesn't mean Americans don't care. It's just at a different level. And I think it's very important to recognize this distinction when dealing with cloud issues, particularly when cloud processing is done in the U.S. So once data crosses international borders, where is it safe? And Augustine mentioned the phrase, "it depends." This is one of my favorites as a lawyer. Whenever people ask me complicated questions whose answer I do not know right away, I often say, it depends. Once, back when the world was simple, although it certainly had other problems at the time, borders stopped things. Borders stopped mail. Borders stopped people. Those borders are now more virtual than anything else. For those of us who are coming from North America, I live right on the Canadian border, and I cannot cross the border without a many-minute stop at customs, many questions. So to travel between countries in Europe and drive through more easily than we drive between states is a real eye-opener, certainly for me and for other Americans. But the fact is, now it's very easy to transmit data anywhere. I was speaking to my veterinarian earlier today. This is not something I could have done previously with such ease. But data goes anywhere. We can be reached. Our information can be shared across borders. And the point of the slide is where your data is, where the cloud is, where the cloud processing happens does matter. So I put two pictures of friendly dinosaurs because this is the way things were in the past. Well, not really. Dinosaurs were never friendly, but they looked good. In the past, the European Data Protection Directive gave guidance. And you can read the slide, but the default was that the transfer of personal data to a third country could take place only if the third country could ensure an adequate level of data protection. There are books that have been written for lawyers about what the definition of the word adequate is. So this is not terribly helpful guidance. The European Commission gave further clarification, but only to a point. And the ultimate directive, which was adopted, I believe, in 2000, enabled U.S. companies, which is where much of the cloud processing and storage occurs. It allowed U.S. companies to self-certify, to say to the world, yes, we are doing a good job, we are protecting your data, and it is sufficient for your needs. That doesn't happen anymore. Well, it's not happening, and it's, well. So in October of this year, the Schrems case, which involved a professional plaintiff, I believe he was a professional plaintiff, sued over Facebook's storage of data in the U.S., and he claimed, rightfully so, that his data was not kept in a sufficiently secure manner. And I've asked Patricia to interrupt me anytime if I stray off. But since that decision, where it was determined that U.S. self-certification was not sufficient, is that data transfers from the EU to the U.S. now trigger special EU data protection directive, the EU Data Protection Directive, and may be subject to scrutiny, legal scrutiny. So many companies use U.S.-based cloud services, and if personal data is kept outside of a U.S. jurisdiction, knowledge of the compliance regulations is not only required, that is knowledge of the rules, but the rules have to be followed. Now, this is still in transition, it's in process. I think Patricia will hit on that a little more specifically than I will. But things are in flux, but the rules that applied up until October of this year no longer apply. As I just said, companies can no longer rely on that safe harbor certification. The safe harbor certification meant that a U.S. business could say, yes, your data is safe, we've got it. And the fact is, we don't know if they did or they don't. No, that is no longer sufficient. Truthfully, I think most of them aren't aware. Patricia's question was, how do Americans feel about this? And the answer is, I think most are not aware. I think this is something that affects American cloud providers, so they may know. But in terms of the general public or even the general technology public knowing, I don't believe that they do. I don't believe that they do. So here's some URLs. Again, these slides will also be available to you if you want the pictures of all of the people that I had on the slide. And so you can figure out who they are. I think I can get most of them, but in any case, the EU now recommends that entities consider using EU-approved standard contractual clauses. These are, again, you'll talk about these more specifically, to ensure that data is compliant and that its storage and processing are compliant. There are two sets of standard contractual clauses for transfers of data and one set for transfer to processors. So one is really about storage and one is about processing. And this information is available at the URL here. I think, wait. My last picture. Oh, no, one more thing. Two more things, 2 more slides. It is very important that, that entities have what's called a WISP, which is a wireless, not wireless, an information security policy to protect the data. It's written. It's not wireless. It's written. We're at Mobile World Congress. I'm thinking wireless all the time. But it's a written information security policy that is a living, breathing document that changes as circumstances do, but so that in the event that someone complains that a service is not compliant, entities can fall back and say, yes, it is. I encourage you in the strongest terms that if your clients are contracting with entities in the U.S. or U.S.-based entities, that you ask to see their WISP. They should be able to provide it, but it's also worth reading, or it's worth having your attorney read. You need to protect the data that you are shipping overseas, not only within your facility and your country, your company, but beyond that. And finally, this is where I was yesterday. Thank you so much again for inviting me and encouraging me to come to Barcelona. And see, George, I said I could do it in under 15 minutes.